statement.
Well, thank you, and I want to thank our witnesses for appearing today. I've noticed a trend in this committee this year. We seem to be on a buyer's remorse tour. First, we had a hearing with the 7 top CEOs of global systemically important banks that focused primarily on their approvals, their overall size, and their recent growth. Next, the committee advanced legislation that would limit the independence of the Consumer Financial Protection Bureau. Now, today, we're examining the potential merger of 2 institutions that have pointed to the post-Dodd-Frank regulatory landscape and the cost of compliance as one of the drivers behind their decision to merge. I can't help but believe this is another example of buyer's remorse on the part of my Democrat friends. It was Dodd-Frank and the resulting 400 new financial regulations that have forced consolidation in the financial services industry. It is my colleagues on the other side of the aisle that have made the largest banks larger while suffocating smaller institutions. Since the financial crisis, the Fed has approved 1,812 mergers of banks. This is the first hearing of this kind in the last 20 years in this committee. Despite the rhetoric, the Democrats have solidified the reality that size equals survival. We will undoubtedly hear today about shortcomings of the bank merger process. And for the record, transparency is a prerequisite for approving a bank merger. Both the Bank Holding Company and the Bank Merger Act clearly outline steps that must be taken. The Justice Department conducts a thorough review of the impact of competition and reports on competitiveness to ensure full compliance with antitrust laws. Federal banking regulators also conduct studies on competitiveness, looking closely at the impact to consumers from an institution's footprint. The merger applications submitted are publicly available, as are thousands of pages of supplemental information. Public meetings have been held, and transcripts of those meetings are available online for all to read. I remind my colleagues that the last legislative change to the bank merger process was actually in Dodd-Frank. Democrats had every opportunity to address whatever shortcomings they will identify today, but they failed to do so. This hearing is being held in the middle of a merger process. Business decisions cannot be made at this time because the 2 institutions remain separate and are prohibited from sharing information with one another, compelled under law from sharing that information. Unfortunately, I expect my friends on the other side of the aisle will ask questions the witnesses are prohibited from answering, prohibited by law from answering. What we do know is this. As part of the Community Benefits Plan announced July 16th, the new bank has committed to open at least 15 new branches in low and moderate income and majority minority communities across its footprint. That comes in addition to the staggering $60 billion committed by the institution to community reinvestment activities. The regulators are examining this and many other possible implications of this merger in detail, which this body is not privy to at this point. Mergers are grounded in procedure. Concerns are not simply swept under the rug. I hope my colleagues understand and respect the limitations under which these folks are testifying today. I trust the witnesses will be forthcoming as possible with the limitations set out in statute. Furthermore, these 2 institutions are, in essence, large Main Street banks doing standard non-capital markets-oriented businesses. This is a standard merger process by which the Fed is well equipped to deal with the law. And with that, I yield back.